Hi, everyone. My name is Cliff Kirsch, and I'd like to welcome you to the BISA and Eversheds Sutherland webcast, the SEC's new Standard of Conduct Rules, Important Considerations for Bank-Affiliated Broker-Dealers and Investment Advisors. I'm happy to be doing this, and also very, very happy to be joined by my colleagues, Ben Marzouk and Bria Adams. Ben's been active in various BISA events and committee, so hopefully, folks on the call have gotten an opportunity to meet at least one of us, through those activities and otherwise. Before we begin, a few quick housekeeping notes. If you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Also, if you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. And if you'd like to receive a copy of the slide deck, please contact me, Ben, or Bria, and any one of us will be happy to send you a copy of the deck. So what we're going to do today is focus on the impact of the SEC's Standard of Conduct rules, and we are going to look at Reg BI, the form, and the advisor interps, mostly with an emphasis on Reg BI and the disclosure. And we'll also pay particular attention and try to call out some issues of particular interest to bank-affiliated broker-dealers and advisors. So we'll look at conflict disclosures that may come into play for bank-affiliated firms, sales contest quotas and non-cash compensation, third-party comp or revenue sharing received by bank-affiliated firms, and policies and procedures. And we also want to mention the CFP designation, which is outside the scope of the SEC Standard of Conduct rules, but just because it's getting so much attention, we wanted to say a couple of words on that. So again, a lot to cover. Thanks for being here. And Ben, I'm going to turn it over to you.
Sure. Thanks, Cliff. And I'm glad everyone's on the line and interested in this subject. We're going to try to cover all aspects of the rulemaking proposal and try to do it from an area that's uniquely tailored to the bank-affiliated model, because as we know, there's going to be certain challenges and compliance implementation issues for bank-affiliated broker-dealers and investment advisors, mainly because their business model is uniquely tailored to certain products and certain business lines that may present certain challenges from the SEC's rulemaking standpoint. For instance, whether there's incentives to push certain banking products or recommend securities transactions that help the banking sector of the business. Banks may, as we've seen, enter into certain preferred manufacturer relationships for certain securities product issuers, for instance, maybe mutual fund issuers, or may even manufacture products themselves through one of their affiliates. And these bank-affiliated broker-dealers and investment advisors will be encouraged to recommend these products, so that to the extent that presents a conflict of interest, or to the extent that there's certain product limitations that the reps on the broker-dealer investment advisor side are constrained by, those type of considerations will need to factor into how a bank-affiliated firm implements the SEC's rulemaking. And then also any sort of compensation issues that are unique to the bank model, whether it's sales contests or quotas that may be used on a promotional or limited basis. Those will need to be factored into how a bank affiliate implements the SEC's rulemaking, different from a standalone broker-dealer or investment advisor. So we'll hope to cover those issues, layering through Reg BI, Form CS, and the investment advisors' interpretive releases, the two that came out and accompanied the SEC's rulemaking. So if we move on to a little bit of background in terms of what led up to the new rules and where we kind of are now, the SEC Standard of Conduct rulemaking has really been the subject of congressional, legislative, and regulatory scrutiny for quite some time now. As this slide makes clear just how far back this debate has gone. As people on this call know, broker-dealers and investment advisors have long been subject to differing regulatory regimes, with broker-dealers generally subject to a suitability standard under FINRA Rule 2111, requiring that any recommended securities transaction be suitable for the investor, and then investment advisors subject to a higher and more demanding fiduciary standard that, while not explicit in the SEC's rules, has been interpreted by courts and regulators to be effectively read into Section 206 of the Advisors Act, which is a general anti-fraud provision. So since there has long existed these differing standards of conduct for broker-dealers and investment advisors, and since the business of these two entities largely overlap in the securities industry, there has been a long-standing push to streamline the standards of conduct for broker-dealers and investment advisors by imposing some version of a uniform standard of conduct across the industry. And this push you really see dating back to 1995 with the Tully Report, later with the SEC's adoption of and the D.C. Circuit's subsequent overturning of Rule 202A11, then with the Dodd-Frank Act, which required the SEC to study efforts to impose a uniform standard of conduct on broker-dealers and investment advisors, later leading up to the Department of Labor's fiduciary rulemaking, which was ultimately vacated by the Fifth Circuit in 2018. And that really paved the way, in many ways, for the SEC to propose its own standard of conduct rulemaking, which is really where we are right now. I will point out just a quick note about state law developments. It's not really the focus of this webcast, so we won't touch on it much, but just wanted to mention that this slide, which shows the genesis of the rulemaking history here, does not show that there is also a parallel path of state fiduciary rulemaking developments, as some states are popping up and claiming that they do not view the SEC's rulemaking as sufficient and that they want a true fiduciary standard for broker-dealers recommending securities in their state. So we're seeing a handful of states, Nevada, New Jersey, Maryland, recently propose enhanced true fiduciary standards of conduct on broker-dealers. It's unclear how these state laws will align with the SEC standard or if they'll even remain intact, as this will most likely end up being resolved by the courts. The National Securities Market Improvement Act of 1996 does preempt state laws that impose differing standards of conduct on broker-dealers, at least different than what is required by federal law. So only certain areas of law are preempted by NISMIA, so the question that will ultimately, like I said, I think probably be decided for the courts, be whether or not NISMIA does preempt these state laws that differ in substantial respects from the SEC's separate rulemaking. But moving on to the background for the SEC's rulemaking, the SEC's rules were initially proposed in April of 2018. Extensive comments from a broad range of financial services industry participants were received after the rulemaking proposal, both consumer groups and financial services market participants. Thousands of comment letters were received. And after reflection on the comment letters, the SEC tweaked the rule, and we'll get into some of the changes they made to the rule, and by a 3-to-1 vote adopted the rules in June of 2019. Jackson voted against. They didn't have a full commission at the time the vote was held, but there were at least 3 yes votes, so they were allowed to move forward. Of course, the SEC now does have a full commission with the confirmation of Allison Lee just a few weeks ago, and it's unclear where she would come out on the rulemaking, and she hasn't really said much publicly, but Clayton had 3 votes needed to move this forward, so that's what got it done. There was a little bit of tension with the report that Jackson released, essentially only released to the full commission at the 11th hour, which he ended up citing heavily in his written and spoken remarks during the open meeting. But either way, it was 3 yes votes, so it was able to move forward. It did essentially establish the same basic structure of proposed regulation best interest, the general obligations, the component obligations, and some of the definitions. There was a new component obligation, a compliance obligation that Bria will get into later, that was added to the final rule and was not present in the proposed rule. And there were some other significant changes to the interpretive language and the rule text as well. The SEC's version of the Reg BI adopting release, it has now been published in the Federal Register, but the adopting release before it was published in the Federal Register was well over 700 pages. 115 of those pages were devoted to the disclosure obligation, which is one of the 4 component obligations. So that did seem to be the focus from actually, in terms of the SEC's interpretive guidance, seemed to be focused around the disclosure obligation. Moving on to the just a high level, what the general obligation, what it is and what it represents. The general regulation best interest applies to broker dealers and broker dealers only. As well as their associated persons. But the point is that it does not apply to investment advisors. So the best interest standard would just be for broker dealers, and it would be when recommending securities transactions or investment strategies to act in the best interest of the retail customer. An important note here is that investment strategy does include recommendations of account types as well as rollovers, transfers, and hold recommendations. Account types mainly being the broker-dealer or investment advisory account. So now a 401k rollover recommendation or transfer would be covered by Reg BI, even if the recommendation is to move to a non-security product or to liquidate entirely into cash. Because if any part of it touches a security product, it would be seen as a securities recommendation, and that rollover recommendation would be covered by regulation best interest. Similar with account types, just the recommendation to open up either a broker-dealer or an investment advisory account would be covered by this rule. For a bank-affiliated firm, where many of them have both broker-dealer and investment advisory accounts available to their customers, firms will need to ensure that the broker-dealer has procedures to ensure that the broker-dealer rep is recommending an account type that is truly in the best interest of the customer, even if that account type means moving to an advisory account that would not be held directly with the broker-dealer. So that's going to be an important distinction, ensuring that the account type recommendation is built into this structure of investment strategy and is therefore covered by regulation best interest. There wasn't much of a definition for best interest. We'll get into this in a second, but it essentially means not placing the rep or the firm's interests above the retail customer's interests. There were 4 component obligations. Disclosure, care, conflict of interest. All 3 of those were covered in the actual proposed rulemaking. The 4th one, however, is new, and that's a compliance obligation. And all 4 of these component obligations need to be satisfied in order to meet the best interest standard. This is different from a safe harbor, which was sort of ran through the proposing release in some ways. Now they're just saying what you have to do, what you're required to do. It's not a safe harbor where if you do this, you will be deemed to have satisfied the rule, and there may be other ways to satisfy the rule beyond that. What they are saying is that if you are going to comply with regulation best interest, you are required to comply with each one of these 4 component obligations. Moving to the transaction and account recommendations, I think we covered most of this already, but one of the main distinctions between the proposed rule and the adopted rule is that the investment strategy includes recommendations and includes hold recommendations. So this would mean that even a stay put and do not move or engage in any securities transaction would be considered an investment strategy recommendation, and firms will need procedures to ensure that it complies with regulation best interest. And then finally, just in terms of an overview about the defined terms in the rule, they did have a set definition section of the regulation best interest. Like I said, best interest is not defined in the rule. They instead offer to explain what regulation best interest means through how an individual firm or a rep would go about acting in the customer's best interest. So that's why the actual adopting release is important to read over, because there's no explicit definition of best interest. And then I'd point out that retail customer investment profile, the SEC did not accept comments to expand this definition, but they did state in the adopting release that the list of factors when gathering information for the customer's investment profile, the list of factors that they put in the release is non-exhaustive. So this is one of those carryover principles from the suitability framework in FINRA Rule 2111, and it's important to note that the investment profile, you may be able to look at factors beyond what the SEC explicitly put in their release when determining what would exactly constitute an investment profile, which is important for satisfying the care obligation under the SEC as one of the 4 component obligations of SEC's regulation best interest. So with that, I'll go ahead and turn it over to Bria to do a little bit more of a deep dive into some of the component obligations of regulation best interest.
Thanks, Ben. So as Ben mentioned, there are 4 components to regulation best interest. The disclosure obligation, which provides prescribed disclosures before or at the time of the recommendation, about the recommendation and the relationship between the retail customer and the broker-dealer. There's the care obligation, which requires the broker-dealer to exercise reasonable diligence, care, and skill in making the recommendation. The conflict of interest obligation, which requires the broker-dealer to establish and maintain and enforce policies and procedures reasonably designed to address conflicts of interest. And the final compliance obligation, which requires the broker-dealer to establish, maintain, and enforce policies and procedures reasonably designed to comply with regulation best interest. So under the disclosure obligation, broker-dealers are required to provide retail customers in writing at or before a recommendation is made, full and fair disclosure of all material facts relating to conflicts of interest that are associated with the recommendation. Broker-dealers also required to provide the customer with material facts relating to the scope and terms of the relationship with the retail customer. So this would include conflicts disclosures related to bank-affiliated broker-dealers, conflicts associated with third-party compensation or revenue sharing, or any other types of payments received by bank-affiliated broker-dealers. The disclosure obligation also includes a titling restriction. Effectively, the disclosure obligation prohibits a broker-dealer and its associated persons from using the term advisor with an O or advisor with an E when titling itself. So the term financial advisor or financial advisor would not be permitted would not satisfy the disclosure obligation under regulation best interest. The second component of regulation best interest is the care obligation. The care obligation includes 3 components itself. So the reasonable basis component, the customer-specific component, and the quantitative component. Under the reasonable basis component, the broker-dealer must understand the potential risks, rewards, and costs associated with the recommendation and have a reasonable basis to believe that the recommendation could be in the best interest of at least some retail customers. So this is similar to FINRA Rule 2111, in which there's a reasonable basis component. The customer-specific component requires the broker-dealer to have a reasonable basis to believe that the recommendation is in the best interest of a particular retail customer based on that retail customer's investment profile and the potential risks, rewards, and costs associated with the recommendation, and does not place the financial or other interests of the broker-dealer or its natural or associated natural person ahead of the interests of the retail. And this, again, is similar to FINRA Suitability Rule 2111, in which there's a customer-specific component, but it is slightly different. And then the third quantitative component requires the broker-dealer to have a reasonable basis to believe that a series of recommended transactions, even if in the retail customer's best interest when viewed in isolation, is not excessive and is in the retail customer's best interest when taken together in light of the retail customer's investment profile, and does not place the financial or other interests of the broker-dealer or its associated persons, making the series of recommendations ahead of the interests of the retail customer. Again, similar to FINRA Rule 2111. So the conflict of interest obligation is the third component of regulation best interest. In particular, broker-dealers are required to establish, maintain, and enforce written policies and procedures that are reasonably designed to identify and at a minimum disclose, in accordance with the disclosure obligation, or eliminate all conflicts of interest associated with recommendations. Broker-dealers are required to identify and mitigate any conflicts of interest associated with recommendations that create an incentive for an associated person to place his or her interests ahead of the retail customer's interests. They're also required to identify and disclose any material limitations placed on the securities or investment strategies that are provided, and also identify and eliminate any sales contests, sales quotas, bonuses, and non-cash compensation that are based on the sales of specific securities or specific types of securities within a limited period of time. And so one thing to note about the conflict of interest obligation is that it includes several material limitations. Basically the material limitations include arrangements that limit recommendations to proprietary products or specific asset classes, or products with third-party arrangements, such as revenue sharing or other bank-affiliated distribution channels. This could also include arrangements in which the broker-dealer recommends only products from a select group of issuers as well. With respect to the conflict of interest obligation and its requirement to eliminate sales contests, this is something that we didn't see in the proposed regulation best interest, but it's essentially, in the adopting release, the SEC notes that it's designed to address high-pressure situations to sell a specifically identified type of security within a limited period of time. However, the SEC doesn't provide a definition for a limited period of time, but this requirement to refrain from or eliminate sales contests does impact bank-affiliated broker-dealers. It's just not clear the time period for which would be an acceptable period for a sales contest, or if the SEC would deem any sales contest for any period of time to be unacceptable under the conflict of interest obligation. So the fourth and final component of regulation best interest is the compliance obligation, which requires broker-dealers to establish, maintain, and enforce written policies and procedures reasonably designed to achieve compliance with regulation best interest. Broker-dealers do have flexibility to design policies and procedures that are reasonable for the scope, size, and risk associated with firm operations and business type. And any policies and procedures that they develop should be uniquely tailored to bank-affiliated broker-dealers. So I will hand it over to Cliff to cover a few housekeeping items.
Yeah, thanks. Thanks, Bria. Thanks, Ben. Let me make a couple of points driving home some of the things you said. I'm going to also try to pick up a few of the questions that have come in, but we're getting a lot of questions. If we don't answer your particular question, we'll be in touch with an answer, or else we'll find some other mechanism to get back to you. So just keep the questions coming in. So that's Reg BI in a nutshell. It's the actual obligation, and then there's four components to satisfy those obligations. And we ended with the last of the components, which is the compliance obligation. And just a point on that to keep in mind, that was not in the proposal, the requirement to establish written policies and procedures. And in a way, it's straightforward and not problematic and logical. We're going to need policies and procedures, but just note that Reg BI allows for an enforcement mechanism for the SEC. So what this compliance obligation does, it would allow the SEC to just test compliance in and of itself. We find a deficiency in the manner in your policies and procedures. So it has meaning, even though it is pretty straightforward. Beyond that, some of the things you heard, totally within scope is account recommendations. And account recommendations are advisory accounts versus broker-dealer account. And that's something, and a recommendation to roll over is another type of thing that Reg BI covers. So we're going to be, by the time of the compliance, we have to get our hands around all of those. And that's one of the biggest things in terms of account recommendations. There's questions that came in again, and we'll try to get to those either later or some other way. We'll reach out to you. The other thing that's a very big thing in Regulation B Best Interest as adopted, the SEC specifically called out that the cheapest product is not necessarily a way to satisfy Regulation Best Interest, and that's important for our group here that we're discussing this. With many of us sell variable annuities or other products, and the SEC called out cheapest does not always mean that you satisfied your best interest obligation. But if you do sell a product which is more expensive, it is one consideration to take into account. And there's going to be an expectation of documentation and getting comfortable where you sell a more expensive product that you've satisfied your best interest obligation. We got a couple of questions about what exactly is the disclosure. Is that the same thing as conflicts disclosure? And just to sort that out a little bit, the disclosure is a separate obligation, and that obligation talks about a number of things. It's full and fair disclosure of the capacity in which the broker-dealer is acting, fees and costs regarding the customer's transactions, the type of services held, and also conflicts of interest. So one question came in, is the conflicts of interest disclosure separate and apart from the disclosure obligation? No, the disclosure obligation picks up conflicts as well as a number of other things. One thing that's emerging out of the gate, it seems like a lot of firms are thinking about an ADV Part 2-like document to satisfy this regulation best interest disclosure obligation, that there'll probably be some sort of document that has the look and a feel of an ADV Part 2 to satisfy this. But again, that's just an early reading of where the industry may be. So what I'm going to do now is just read the CLE text for those of you who are looking for credit. And then, Ben, I'm going to hand it out to go sort of out of scope and talk a little bit about the CFP, and then we'll continue with the discussion. So for those of you who would like to receive CLE credit for today's webcast, our confirmation code is obligation. So again, that's obligation. So please use that code for the sign-in sheet available for download from your viewing console to get CLE credit. And Ben, I'm going to turn it back to you.
Thanks, Cliff. So I wanted to cover, before we move on to Form CRS, a few more items related to regulation best interests. The first has to do with the CFP designations, and this mainly relates to Reg BI only from an alignment with regulation best interests and how firms are going to try to incorporate CFP designations separate from the obligation to act in the customer's best interest. So this is an area that's been getting a great deal of attention lately, and it's the Certified Financial Planner Standard of Conduct. So separate from the SEC standard, the CFP has adopted new standards that take effect on October 1st, 2019. And that's before the SEC's effective date. I saw a question about that as well. The SEC's effective date is June 30th, 2020. So that's when firms are expected to comply in full with the SEC's regulation best interests and Form CRS. And the Certified Financial Planner designation and their fiduciary standards take effect October 1st, so pretty soon. The CFP standard imposes a true fiduciary standard on anyone with the CFP designation. So that they must act in the best interest of their clients when providing financial advice. And this includes, 1, a duty of loyalty, 2, a duty of care, and thirdly, a duty to follow the client instructions. I note a couple things about this. First, note that the loyalty and care concepts both include important traditional fiduciary elements that were dropped from the SEC standard. Namely, this would be the without regard to language in the loyalty obligations, so that the CFP must act without regard to its own financial or other interests, a much higher standard than simply not placing the firm's interests above the customer, which is essentially what the SEC's rulemaking related to best interest did. In addition, the duty of care includes the prudence language that was dropped from the SEC's care obligation for regulation best interest. So those are a couple important distinctions where the CFP standard goes explicitly beyond what the SEC standard adopted. So the key point here is that, especially for bank-affiliated firms, is that bank-affiliated firms have reps that commonly use these CFP designations. So for these reps, there will now be the SEC standard of care and separately the CFP's fiduciary duty. So firms are going to need to think about what they're responsible for supervising. Are they taking on duties to ensure that the rep complies with its CFP fiduciary duties and, adopt policies and procedures specific to the CFP duties? The bank-affiliated reps that have obtained the CFP designations may be looking to the bank affiliate or even expecting the bank affiliate to defend them if a customer complains that there was a violation of a CFP fiduciary principle. So making sure that the channels of communication and that the supervisory responsibilities are clear between each standard of conduct, that's going to be important moving forward. This is, as we said, a separate standard from regulation best interest. So firms have an obligation to adopt policies and procedures related to Reg BI, but how they supervise the CFP designation, if they supervise it at all, will be a separate question that they'll need to think about through with their legal and compliance departments. Before moving on, I'll pause there really briefly to see if Cliff, you have anything to add with the CFP angle.
Yeah, so thanks, Ben. So just to drive home, so we're out of scope, right? We left Reg BI, and just to talk a little bit about the CFP, which is totally separate than Reg BI and what the SEC did. And the reason why is we're getting flooded with questions from them, just from clients. So again, we want to spend a little bit of time on it. We'll get back to the SEC rulemaking in just a minute. The standards went into effect October 1, are going to go into effect October 1, 2019. But I just wanted to make sure folks are clear that the CFP board has agreed to delay enforcement of the standards for several months just to better consider the implications of Reg BI. And basically what they're hearing from a lot in the broker-dealer industry is, hey, we just got this rulemaking package from the SEC. We need to figure out things. So what the CFP did is say, hey, we're going to delay enforcement for several months. And Ben, just to drive home a couple of things along what you were saying, what broker-dealers now need to decide is whether they're going to stay silent, basically say, your designation, your CFP, to their financial advisors, your designation is your designation, but we're not going to have policies and procedures about it. Whether we are going to have full policies and procedures about it, and also whether we're going to allow you to market it. Some firms are thinking about, we're hearing about a range of considerations. You hear some discussions about asking financial advisors to drop the CFP on as one extreme. Others are saying, hey, it's fine to keep it, but we just want you to make reference to the CFP on your business card. Others are saying, certain are approving certain type of marketing. But that's what firms have to consider over the next few months. For now, we're seeing no interest in FINRA and the SEC looking at what firms are doing, and that's logical. It would make sense, but I would say to the extent that firms have policies and procedures about the CFP designation, then it's fair game for FINRA to look at during exams. So with that, that's the CFP. With that, I'm going to turn it back over to you to continue with the SEC rulemaking.
Yeah, thanks for that, Cliff, and thanks for clarifying the point about the effective date versus enforcement date for the CFP standard of conduct rule, since that is important. They did make an effort to try to align with the SEC's rulemaking, at least from an enforcement standpoint. A couple quick notes on Reg BI before we move on to Form CRS. First, from a record-keeping standpoint, there were new rules adopted so that the best interest standard isn't just a standard lacking any teeth. There will have to be actual firm records maintained on behalf of the broker-dealer to ensure that they have complied with regulation best interest, and, for instance, captured all of the information related to a customer's investment profile. So all the factors that you would look to when evaluating whether or not the recommended securities transaction fits within the CARE obligation. This should all be recorded, all those factors and how the customer's investment profile fits up with the recommended transaction. From a disclosure standpoint, you'll need to document when they were made to the customer, the disclosures, how they were made, who made them, the rep associated with the account. So when you think over the disclosure and CARE obligations, those are two areas where records will need to be maintained. And this is a record-keeping requirement that will most likely, I would imagine, require firms to build, either new systems or modifications on their record-keeping systems, because this is this is new information that firms will be capturing, and this is the easiest way for a firm to get dinged on an enforcement action and not have the records backing up the recommended transaction. So it's important that firms do make the appropriate system builds or system modifications to capture the records. And then finally, as an effective date point, and I touched on this briefly, the effective date for Reg BI, the implementation date is June 30th, 2020, and the SEC believes this is sufficient for firms to come into compliance with the rule. It remains to be seen whether or not the SEC will extend this deadline in the future. It is a very narrow period, less than a year from now, and I would imagine, depending on how much noise the industry makes, this date may or may not be extended a bit in the future to allow for those very system builds that I was just discussing under the record-keeping requirements. This is going to require an actual lift and a build on the part of firms. And doing that all before June 30th, 2020 doesn't leave much room for error. There is also, related to the effective date, there is the SEC has established an agency, a committee to encourage firms to actively engage as questions may arise, and they have an email address that firms may email the SEC directly to get some added insight. With that, we want to pivot and shift gears to cover the remaining a few areas of the SEC's rulemaking, namely Form CRS and then the two investment advisor interpretations that accompany both Reg BI and Form CRS. So Form CRS is a short 2 or 4 page relationship summary document explaining the relationship and services offered by the financial professional to the retail customer. As we discussed earlier, one of the key reasons why the SEC has gone down this rulemaking path relates to the differing duties and standards of care between broker-dealers and investment advisors. So given their overlapping functions, the SEC has felt that many investors, especially retail investors, were confused about the distinction between brokers and investment advisors and unaware that there are, in fact, different standards of conduct between a broker-dealer and investment advisor. So a customer may not know that when they go and get a recommended transaction from a broker as opposed to an advisory recommendation from the investment advisor, that the individuals making those recommended transactions are held to different standards and treat the customer's interests differently. So with that, that sort of underlies the purpose of Form CRS. It's an attempt to clarify some of the confusion related to the differing standards of conduct. Form CRS, and that's why we put here the implementation challenges and questions. Form CRS did receive quite a bit of criticism from both sides of the industry. It was when it was proposed. It was seen as duplicative, unnecessary, creating a mountain of paper at the outset of a customer relationship, and that the actual content of what is disclosed in the Form CRS may serve to even further confuse investors, and some of the required language, at least in the proposed Form CRS, wouldn't apply to certain customer relationships. So the SEC kind of did a road show after it was proposed and went around to different parts of the country and met with individual retail investors and tried to solicit feedback as to whether or not the proposed Form CRS accomplished its goals of truly clarifying the distinction between the two entities. And to the SEC's credit, they did modify Form CRS in many important, significant respects. I want to quickly highlight some of the main changes or improvements the industry would say that the SEC made between the proposed Form CRS and what they ended up adopting just last month. So first, they shortened it from 4 pages down to 2 pages for standalone broker-dealers and investment advisors. It would be required to be a maximum of 4 pages for dual registrants. In addition, they allow a more flexible approach with the format and presentation of the Form CRS. The proposal was primarily a written narrative document. Now the SEC has shown a willingness with Form CRS to be presented and delivered to the customer through video stream, audio, different forms of streaming or video content online. So that's one important distinction. In addition, the 8 categories in the proposal were reduced to only 5, and we'll cover those 5 categories shortly. For instance, key questions is no longer a required category. They just have these conversation starters that filter throughout the Form CRS document and are meant to encourage dialogue, open dialogue about the relationship and services between the customer and the financial professional. Another difference is that they have much more flexibility, the SEC does, in Form CRS with the prescribed language. The proposal of Form CRS included many required disclosures and specific prescribed language that was required to be in the form. There's some of that still, but it's much less than what was in the proposal. So there is more flexibility in terms of allowing firms to express and articulate what exactly what exactly they want to disclose to the customer. And then fifth and finally, an important distinction is the titling restriction that Bria mentioned earlier. That it used to be part of Form CRS as an explicit rule. It now has been built into Reg BI as part of the disclosure obligation and the disclosure of the capacity in which the individual is operating. So you can no longer use advisor or advisor, both with an O or an E, and that titling restriction was moved from CRS to Reg BI. So just moving on, I wanted to briefly highlight some of the fundamentals of the form. As I mentioned, there are 5 prescribed areas that the form must cover. It must be an introduction section, a description of the relationships and services the firm offers, the fees, costs, conflicts, and standard of conduct. 4th, a disciplinary history section, and 5th, a where to find more information with appropriate hyperlinks or numbers to call section. Like I said, conversation starters must be kind of filtered throughout the document. They do allow more permissive use of charts, graphs, and tables than was in the proposal. And I wanted to, before we get into the delivery requirements, I wanted to briefly cover a couple points related to items 2 and item 3. With item 2, note that the disclosures related to relationships and services, these are separate from the disclosures in regulation best interest. So The headings, you must have headings in there reading, what investment services and advice can you provide me? That's required language. But these disclosures about relationships and services, including investment authority, monitoring, account minimums, and so forth, these are all separate from the Reg BI disclosures, and as that is a parallel document. Moving to the third item in Form CRS, fees, costs, conflicts, and standard of conduct. I suspect this is where most of the meat of Form CRS and most of the discussion points and conversation starters will probably be driven because, for instance, one of the conversation starters that might get a lot of dialogue will be, if I give you $10,000 to invest, how much will go to fees and costs and how much will be invested for me? You don't need to propose answers to these conversation starters, but that will encourage dialogue, at least related to this subject. I would note, before going to delivery obligations, for the bank-affiliated model, I think the revenue sharing payments, especially any sort of bank sharing or revenue sharing arrangements with different product issuers and manufacturers, that's going to be an important disclosure that would be unique to the bank-affiliated model. So to the extent that there are fees or revenue received by the firm or the rep that would constitute some form of revenue sharing that's unique to the bank-affiliated model, that will need to be disclosed in this part of Form CRS. So with that, I think we can move on to the delivery requirements. So I'll hand it off to Bria.
Thanks, Ben. So with respect to delivery requirements, as Ben mentioned, Form CRS, the relationship summary is a requirement for both broker-dealers and investment advisors. So with respect to broker-dealers, I did see a question as to whether Form CRS would be required to be delivered for only new accounts or accounts open going forward, essentially, or would other accounts be grandfathered. Form CRS must be delivered to retail customers in 3 instances. First, when a recommendation of an account type, a securities transaction, or an investment strategy involving securities is made, or when placing an order for a retail customer, or when opening a brokerage account for the retail investor. As Ben mentioned, dual registrants also need to deliver the Form CRS, and they have a choice as to whether combining those documents for both the broker, dealer, and investment advisor, or providing documents that are separate. But that delivery has to occur at the earliest of either the trigger for a broker-dealer or an investment advisor. Duly registered firms and their associated persons who only offer broker-dealer services through a duly registered firm need to note, as been mentioned, that the SEC has explicitly stated that the information contained in Form CRS will not be sufficient to satisfy Reg BI disclosure obligations. With respect to the delivery requirements that apply to investment advisors, Form CRS has to be delivered to retail investors before or at the time an advisor enters into an advisory contract. And for existing clients, it needs to be provided before or at the time an advisor either opens a new account for the existing client that is different from the retail investor's existing account, or recommends that the retail investor roll over assets from a retirement account into a new or existing account or investment, or at the time, before or at the time the advisor recommends or provides a new investment advisory service or investment that does not necessarily involve the opening of a new account and would not be held in an existing account. With respect to the kind of updating and delivering and making amendments to Form CRS, amendments are required to be filed within 30 days after any information becomes materially inaccurate. And that goes for a broker-dealer or investment advisor. With respect to communicating updates to retail investors, retail customers, if changes are made to Form CRS, the firm has to communicate those changes to each retail investor who is an existing client within 60 days after the amendments are required to be made and without charge. The communication can be made by either delivering the amended Form CRS or by communicating the information through another disclosure that is delivered to the retail investor. In addition, a firm must post Form CRS on its website and deliver a current Form CRS to each retail investor within 30 days upon request. Finally, the initial Form CRS for broker-dealers must be filed with CRD, the Central Registration Depository, no later than June 30th, 2020. A broker-dealer must record the date a Form CRS is provided to retail customers, including those provided before an account is opened. And for records, they must be kept for at least 6 years of any CRS that is provided. For investment advisors, Form CRS is included in Form ADV as a new Part 3 of Form ADV. The initial Form CRS must be filed electronically with the IARD no later than June 30th, 2020. And an investment advisor must record the date when a Form CRS is provided to a retail client, and those records must be kept for 5 fiscal years. And I'll hand it over to Cliff to discuss the interpretive releases.
Yeah. So before that, and thanks, Bria. Just a couple of thoughts on the CRS. So what we'll do is we know we're getting towards the end of the hour. I'll make a couple of points about the CRS. I'm also going to try to capture a couple of the questions, then talk a bit about the advisor interp. But again, we'll stick to the time allotment. So I just want to make sure it's clear for folks that we're really talking about a disclosure regime between the CRS and the Reg BI that calls for 2 different disclosure items, the Reg BI disclosure and the Form CRS disclosure. The Form CRS disclosure is a prescribed form. It's a prescribed format, but it is short. We got a few questions. Is it really a short document? And it is a short document. If you're a standalone advisor, 2 pages, a standalone broker-dealer, 2 pages, and if you're a dual registrant, it's 4 pages. So for a lot of us who are dual registrants on the phone, we're going to have to think about whether we want to do 2 separate relationship summaries of CRSs or 1 combined. Just so you know, the SEC goes out of its way to encourage 1 combined. But again, they do give the flexibility. The Reg BI, there's no prescribed format for the Reg BI disclosure, but as said before, what we think will emerge and what we're seeing emerge right now is, again, probably an ADV-like Part 2 disclosure document. But again, the SEC provides flexibility as to how and the manner, how you provide the Reg BI disclosure. Some of the other things you're going to need to think about with the CRS is we made reference to conversation starters. There's certain parts of each of the CRS where the SEC has questions that customers are encouraged to ask. We need to think about whether we want to prepare answers for our financial advisors or whether we want to keep it just free-flowing, because it's questions as to, assume I had $10,000 to invest. What would be a preferred like account type? What type of fees would I be assessed? Things like that. Very open-ended questions. So we have to think about how we want to provide responses or not to the financial advisors if they do get questioned as to those conversation starters. And the big thing that we're going to have to think about is, we talked about the delivery obligation. How are we going to accomplish delivery? And it's really at the time of the recommendation for dual registrants. Bria mentioned there's a couple of trigger points for a broker-dealer at the time of recommendation, the time of opening up an account. For advisors, it's the time of the advisory relationship. For dual registrants, I really think the default is going to be at the time of the recommendation, and we're going to have to think about how we accomplish that. The other thing, I'll just take one of the quick questions that came in. Is this only for new clients? And it's not. There's not a broad grandfathering for existing clients. The CRS will have to be delivered if there's certain triggers. For instance, if there's a recommendation of a new brokerage service or investment, that would be something that would trigger a delivery of a CRS to a retail investor who's an existing customer. So there's a couple of triggers, and we're going to have to look at those with respect to our existing client base. All right, we have just a couple of minutes left, and I want to make reference to the Advisors Act. There were two interpretive guidance pieces that were released. They're not rules. They're formalized guidance released by the SEC, but again, not rulemaking. And we mentioned the effective date of June 30th, 2020 for Reg BI and CRS. That's not the case. These interpretive releases are effective as of today. They were effective when released in the Federal Register, and that's because the SEC said we're just clarifying, we're just restating, and there's really not much new here. And again, I think a lot people would take issue with that, saying that there's some new things here, but what it is, it's again, no matter what, it is effective as of today. So there's two releases, and one restates what the fiduciary duty is for investment advisor. What does the duty entail? And in a nutshell, it entails a duty of loyalty and a duty of care, and we always knew that. Nothing new there. There's always a duty of loyalty and a duty of care, and the duty of loyalty is what? A duty to deal with conflicts. It's a duty to provide fair and effective disclosure of conflicts, get informed consent. That's the duty of loyalty. The duty of care, though, is an obligation to act in the interest of clients, making sure you have enough information about clients, making sure you get updates to the information, making sure that the strategy you recommend to the client meets the client's needs. That's the duty of care. That's been less developed under the Advisors Act and Advisors Act exams and advisor just pronouncements over the life of the Advisors Act. We're seeing a real interest in this interpretive guidance to the duty of care, and you could expect to see SEC examiners ask about the duty of care over time, how you satisfy the duty of care. So there's a duty of loyalty and a duty of care, but, and this is critical, one thing that the SEC says, there's an overarching duty to act in the best interest of clients. So in addition to satisfying your duty of loyalty and your duty of care, you have to act in the best interest of clients. So what that means is a lot of thinking over the past was, if you satisfy the duty of loyalty, let's say with respect to the receipt of third-party compensation by giving effective disclosure, you're done. You completed what you need to under the Advisors Act. You receive third-party compensation, but you give disclosure about it, you give effective disclosure, and you get informed consent. What the SEC is saying now is that's not it. In addition to disclosure and informed consent, you, advisor, have to be sure that that's in the best interest of client. And that might cause some of us to create conflicts committee or the like to make that determination. The SEC doesn't address that, but again, that's a very significant change in this interpretive release. It's getting a lot of attention, and it's worth attention on your end. The other thing is less monumental. On the next slide, we get to the solely incidental. What the SEC did is it redrew the boundaries, and I'm just going to go 1 minute more and then we'll end. It redrew the boundaries of the broker-dealer exclusion in the Advisors Act. And now we're in the definition of advisor, 202A11C of the Advisors Act, which talks about the broker-dealer exclusions. Broker-dealers are excluded to the extent that their advice is solely incidental and they're not giving and they're not receiving special compensation. What the SEC says in this interpretive release, two things. One, if you take discretion, you cannot rely on the broker-dealer exclusion. That's one thing. But the other thing they did, and this has consequence to us, is monitoring accounts. To the extent that you as a broker-dealer agree to monitor accounts on an ongoing basis, that's outside the broker-dealer exclusion. Monitoring account is something that, on an ongoing basis, is something that advisors do, and broker-dealers monitoring is more limited, more prescribed. So that's something that's going to cause us to go back to our policies and procedures and see how we address it there. We are just about at the end. We wanted to thank everyone for joining, and thanks everyone for your questions. And I said we'll be back in touch with those. And remember to please contact either any one of us, and we'll be happy to share a copy of the deck. And with that, we'll sign off and say thanks again for joining.